This morning, we do have Mr. Bode Ayeku, who is the President, Institute of Chartered Secretaries and Administrators. Good morning, sir. Thank you for coming on today.
Good morning. Compliments of the season.
Thank you. And we also do have Chukwudi Ofili, who is a legal practitioner, joining us via Zoom in Lagos. Good morning, Mr. Ofili. Thank you for joining us as well today on the program. Well, it's the Finance Act. Yeah, the Finance Act. I mean, some part of it was still talked about today. In some of the dailies, it has huge implications to different sectors of the economy, actually. But there is this clause there which talks about, well, maybe we might just go ahead and take a look at that slide, about certain dividends, the shares, the funds have got to be remitted to a certain fund as it plays out. But we'll get to see that this morning. But Mr. Philly, if you could just go right ahead and perhaps talking about the intendment of the drafters of this, from your understanding, because there's been several reactions concerning that, do you think that was well intended?
Well, with respect to the provision in the Finance Act 2020 relating to unclaimed dividends and unutilized amounts in dormant bank accounts, the intention of the drafters is actually one that is laudable. It is one that seeks to provide a means for the government to raise funding. I think the issue with it is, clamors from the shareholders saying that this actually affects their rights to own property, right, and their constitutional rights to own property. But I think the key provision in the Finance Act, which deals with it, is the Finance Act says that this provision is actually drafted on the back of Section 44 of the Constitution of the Federal Republic of Nigeria, which deals with compulsory acquisition of private property. So the key thing here is that the government is going to act as a trustee, right, for these funds and utilize these funds for projects and infrastructural development. The key thing here to note is that notwithstanding that the federal government has borrowed these funds are still available to be claimed by the appropriate shareholders and any of these bank account holders at any time. So the key thing is that it's held in trust by the federal government. The government is not compulsorily acquiring dividends and then amounts in these bank accounts without recourse. So if in the future those persons who did not claim these dividends or left these deposits in these bank accounts dormant come to say that, oh, these funds actually belong to me, and bring the necessary evidence to show that they belong to them, they can then claim this in addition to any interest or yields on those amounts.
Let me just read that section so that we can all follow through with that one, because I mean, when people see this kind of headlines, the way they interpret it is different. They think, what's government trying to do with my money? But look at that. Section 77 says, from the commencement of this act, any unclaimed dividend of a public limited liability company quoted on the Nigerian Stock Exchange and any unutilized amounts in a dormant bank account maintained in or by a deposit money bank which has remained unclaimed or unutilized for a period of not less than 6 years from the date of declaring the dividend or domiciling the funds in a bank account shall be transferred immediately to the Unclaimed Funds Trust Fund. That's 1 through to 3. Well, Mr. Ayeku, this provision, how does it sit with you?
As an institute, we earlier expressed our opinion, and we released our position paper on the 19th of November when we saw the draft of this particular bill. And we felt that it was something like an inducement of a breach of a contract between the company and the shareholder, the bank, and their customers. Because we have a constitution that is still in operation in Nigeria, that is the 1999 constitution, that talks about the right to property. And the constitution states clearly that that particular right cannot be taken away from you. That is, nobody can deprive you of your right except the due process is followed, and you are given the opportunity to explain your side. You know, the whole intention of this is that government is looking for money, and we know that. But it would have been better for government to come out clearly. We are borrowing. It's not a new thing. Individuals do borrow, government do borrow. About borrowing indirectly and also legislating that companies should transfer funds, banks should transfer funds of their customers to a trust fund appears very strange. And that's why we advise the government that what government needed to do in respect of unclaimed dividend was to make it very simple. The institute believes that dividends should be accessible to shareholders in perpetuity. And we like what the government has done. Government has incorporated that in this particular finance bill. However, the government, in incorporating that, did not follow our recommendation. They have now created two regimes of unclaimed dividend. Because this particular, if you look at the section you read out, particularly section 60, that talks about modification of the provision of section 432 of CAMA, dealing with unclaimed dividends, only relates to perpetuity now, relates to unclaimed dividend of public listed companies. So it means that if you are a public company and you are not listed, your unclaimed dividend of a shareholder ends when it is 12 years. If you are a private company, your unclaimed dividend can no longer be actionable after 12 years. Whereas if you are a listed company, unclaimed dividend becomes accessible in perpetuity. And we advise the government in November that what government needed to do, very simple, for the safety of funds, is for government to say unclaimed dividend maybe after 6 years should be invested in government securities. Government is looking for money. So if government says securities, they'll be able to get this money in such a way that you leave the management of this unclaimed dividend to the companies and the registrars. And because government suddenly cannot have this database and cannot manage the process going forward, it looks attractive to the government that there is idle fund here. But there are a lot of complexity around it regarding management. And that is why every company has an external registrar managing these shareholders. And in Nigeria, in respect of the public companies, we have more than 1 million shareholders. And if you look at the unclaimed dividend, we have not less than about 500,000 shareholders that have this particular claim. And the challenge will be when you transfer this fund to the government, how will the DMO now have the time, the resources to
because they are to manage this
funds. They are to manage the funds because they will not be transferred outside the registrar, outside the company. And this is, we are talking of private funds now to be managed by government. I don't think they have the human resources, and I don't think they have the expertise. And that's why we advise the government, instead of going through this long route, what you need to do is that just compare listed companies or companies generally and banks, that when you have these unclaimed funds or dormant funds in dormant accounts that is of a particular number of years, invest them in government securities, and the instrument should be well tied to that. This is, for example, if it's unclaimed dividend, it's unclaimed dividend in respect of XYZ company, and that particular process should be used for the satisfaction or the payment of the owners of those funds. Now, the challenge is that moving the funds to government, it's not government's funds, it's private funds. And there is no way we can run away the infringement of the constitution that is so glaring now, because this particular law is not made, this transfer, compulsory transfer by companies or by banks to DMO, is not as a result of a court order. That is, you have maybe government is forfeiting the proceeds. Is legitimate funds of individuals. And we have said that the major challenge with this particular law is that there is no attempt by this law to solve the problem of unclaimed dividend, which should have been the major focus. Because when there's a problem, you don't run away from the problem. You address the problem. And that is why we advise the government, we advise the National Assembly, we advise SEC that let us focus on the problems of unclaimed dividend. Let us eliminate it. Because when you just take away this money, the problem is still there.
Yeah. Okay, but Mr. Ofili, pardon me, Ayo, just to follow up on that one, because I'm wondering now, this is not the first time that this law came through, actually. In 2006, the National Assembly threw it out. And then they picked it up again this time around, and then it passed it. So, Mr. Ofili, tell us, what is it that was missing here? Because if the industry stakeholders advise government copiously, as you've heard, including the Assembly, why is it that the drafters, or what do you think could have happened, why they didn't take all of this on board? Because, as you just heard now, there are still problems that have not been addressed, which many thought should have been put before just the quest to get funds?
So I think there are a couple of issues that need to be addressed. I've had conversations around the constitutionality of this provision. Like I said, the Finance Act was this particular provision is enacted on the back of Section 44, right? There's no doubt that every Nigerian has a right to own immovable property and as well movable property, which would include cash in those bank accounts and shares and the dividends that are attached thereto, right? But it's important to note that this provision has actually been drafted on the back of Section 44, right? Section 44 of the Constitution actually provides for compulsory acquisition of property. The key thing here is that where the government, perhaps I should just read this provision. It says no movable property or any interest in any immovable property shall be taken possession of compulsorily, and no right over or interest in any such property shall be acquired compulsorily in any part of Nigeria, except in the manner and for the purposes prescribed by law. Right? Some of those things requires prompt payment of compensation, right, to the person who owns that property, and gives to any person claiming such compensation a right of access for determining his interest in the property. The provision of the Finance Act goes further to say that not in this section shall be construed as affecting any general law relating to trusts and trustees. So if you look carefully at the provision that we are considering right now under the Finance Act, you see that what the government has done is to put itself in a position of trust as a trustee. And what this means is that the federal government, through the Debt Management Office, is a trustee, and the owners of these shares and the dividends attached thereto, as well as the cash in these dormant accounts, will be the beneficiaries of this trust, right? So what this means is that the government has, in effect, is a special debt, borrowed these sums of money, right, but still stands in the position of a trustee. Being a trustee means that at any such point that these beneficiaries become known and provide evidence that they actually have rights to these monies or dividends, they will be given back to these persons by the FG, by the federal government. It's also important to note that people have talked about the capacity of the DMO to manage this trust fund, right? It's important to also know that the Finance Act provides that in addition to the DMO, there will be a governing council chaired by the Minister of Finance responsible for the trust fund. The composition of this governing council includes people with expertise, right, and people who are non-partisan, right. It includes the governor of the Central Bank of Nigeria, the Director General of the SEC, Managing Director of the NDIC, a representative of the registrars of companies, two representatives of the shareholders associations, and a representative of the bankers committee. Finally, the director general of the DMO would be a secretary to the trust fund. So this takes away the issues relating to competence of the DMO, whether or not there will be transparency, because what they've now done is to take into consideration all the interests of stakeholders who will now be part of this governing council, right? So with respect to one, the constitutionality, right? This was done in accordance with the provisions of the Constitution, right? And what this doesn't take away these funds from people who own them, doesn't take away the dividends from people who own them, right? What it just does is that it is put in trust in the care of the federal government. And at such time as people lay claims to these funds, right, the DMO, there are provisions in the Finance Act where the DMO will then transfer these monies and all interests that have accrued over time to the owners of these funds. So
Well,
for constitutionality,
yeah, Mr. Falonja, we'll come back
yes,
to that if you don't mind, but I'm a little confused. So on the one hand, it's a
yes,
borrowing. Is that correct? On the one hand, it's a borrowing.
yes,
On the
yes, it
other
is.
hand,
It is.
it is
It is deemed as a
compulsory.
special debt.
Just one moment. On the one hand, it's a borrowing by the federal government. On the other hand, it is compulsory. So even if I don't want to borrow the federal government my money, I am compelled by law to borrow. please. How is that not a breach on right?
Because so it's not a breach because it's in line with the provisions on compulsory acquisition, right? So the government can compulsorily acquire property, but in doing so, you must have certain conditions in place, right, that do not fetter those rights in absolute. And some of those provisions are what I read, including your ability to come back and say, okay, I now lay claims to this property in the form of dividends and then the cash in his account. And then I want this back. And the government then hands it back to you because they act as in a position of trust to you. So in essence, the property is still belongs to these persons, but at the moment they are unclaimed. So we don't know who they belong to. These accounts are dormant and have not been used. It's important to note that by including the timeline, right? The timeline of 6 years. This also caters for issues related to statute of limitation on being able to exercise your rights on those properties. So these are measures that we put in place under the Finance Act to ensure that those rights are not fettered. You have
But
those
some of
rights,
the,
but if you don't come forward to
yeah.
claim ownership, then you've slept on your rights, so to speak, for those 6 years.
But some of the issues that Mr. Ayeku raised is that because you cited compulsory acquisition from the 1999 Constitution, but some of these dividends, I mean, we also do know, I think Mr. Ayeku will speak to it subsequently, for those who are deceased, and then people who are waiting to claim some of these things, some of these cases are even in court. So then this law comes through, and he says, look, there hasn't even been any court order to ensure that this kind of things happen. So what happens in the event that some of these cases are subject of litigation way before this law came into pass? How is that going to happen? Are they supposed to throw away those cases that are pending in court before the law came through?
So we're not saying that those cases should be thrown away, right? The key thing here is that those dividends have not been claimed, right, as at that time for 6 years. At such are determined either by a court of law or some other process, then whoever it is that lays claims to those dividends or amounts remaining in those accounts can then lay claims to it and then ask that those funds be transferred. So the key thing here is that the funds have not been transferred to the federal government in perpetuity, right, without recourse. So you still have recourse. So there's a right to redeem, so to speak, to get back the property, right? So that right has not been taken away from you. The ownership has not been taken away from you. That's why there's that concept of a trust, right? That trust says that the federal government is holding this in trust for you. You're a beneficiary, and at such time that you have, evidence of ownership, you can come and get your money back or your dividends back.
So what do you say to lawyers who think that by virtue of Section 6, subsection 6 of the 1999 Constitution, that nobody can actually tamper with this fund unless there is a court order?
Well, so the thing is, it's a question of interpretation, and to be honest, I foresee a situation where there'll be a lot of cases going forward where people will challenge the constitutionality of this provision. So there's no doubt that this provision is very controversial, right? And people would have different interpretations to it, and chances are that we would see a lot of cases arise as a result of this provision. And then you get to hear a lot of lawyers who hold different positions on these issues. But I think at the point where a court, examines these provisions and gives a pronouncement, perhaps there will be more clarity and certainty as to how this would operate or work in the near future.
Let me ask you the same question I asked him a little earlier. Some of the responses generated the follow-up that Chamberlain took on. it's a borrowing on the one hand,
Yes.
and it is compulsory. Now, let's imagine for once, there was a vital question that you asked the other time. Why did those dividends become unclaimed? Why are those accounts dormant? You said those questions, some of those questions need to be asked. What are those questions that need to be asked?
Okay, let me just respond to three issues raised by my learning friend. The first one is that he said the federal government is the trustee. That raises a legal question. Can a trustee borrow from a trust fund? It's not possible.
That's conflict of interest?
Conflict of interest. So the other point is that he also said that the owners of these funds are unknown. That is not true. Unclaimed dividend companies are required to publish their names. They are known. The challenge is that there are bottlenecks, and that is why they cannot access this dividend. For example, a lot of them, they are still battling with the application at the public registry to get letters of administration, to get probate. And unless you get this, you have to pay 10% of the value of those things, even though the beneficiary are not sending. That's why a lot of them just just abandon them. That it doesn't work. There is hardly any Nigerian that does not have an interest in unclaimed dividend, because they know the money is there, but the challenge is that where do I get 10% of the value of assets that we are not even selling to pay to the government? So they decide to concentrate on their key priorities. How do we fend for those left behind? Those are their key priorities. So they are known. The other point, which is what is of major interest to all the listed companies, is that there will be litigation. He alluded to that. And that there will be litigation is so clear. If you recall the controversy or the issues raised by shareholders and shareholders association on the 23rd of December, Independent Shareholders Association of Nigeria actually did a 1.5 pages advertorial in the Punch newspaper saying that they are going to challenge this particular act. And by the time we have scenarios like that whereby this shareholder decides to institute court action, they will join some of these companies. And that is where the companies, the listed company, will be disappointed and say, what kind of distraction is this? We have more than enough challenges to cope with. Now we are being saddled with another layer of challenges. And some of them will say, fortunately, this particular act is targeting listed companies. Yeah. So what is the special advantage of being listed? Nobody goes to the market to look for product of listed companies. You go to market to buy any product. Nobody look for services of listed companies. So there are no special benefits when you are listed. The mere fact that you are listed does not confer on you tax benefits. So the question is that a lot of companies are there because it's historical. We have been there for a long time. It's a club. Let's be there. But when they see all these challenges, they are likely to leave. And now to your question.
Pardon me. You'll come to that. Okay. When we return in just a moment. We need to go to break. Please join us again. Welcome back. Well, we've since been joined by Mr. Albert Folorunsho, who is the Managing Consultant, Pedable Professional Services. He will be giving us his perspective a little later. But let's get back to Mr. Eke. You were making a point before we went to break.
Okay, just to respond to the question that we have a federal government that is willing to borrow, the borrower, and what is the problem? The challenge is this. When you talk about lending, there is a willing borrower, there is also a willing lender. And as I said, the federal government is already borrowing, so there is nothing new. It will be better for the federal government to say, we are borrowing. And that's what we recommended as an institute, to say, just make it mandatory for the safety of these funds that a percentage of these funds should be invested in government security, which is borrowing. Because the challenge as at now is that the Act talks about whenever the shareholder comes forward to claim his dividend, that they will pay the dividend and interest and the yield. What is the percentage? We only have the percentage in terms of penalty that will be applied or that will be paid by the company that and the banks that fails to remit is tied to monetary policy rate. Whereas the yield that the government will pay to the shareholder or the bank customer is not stated.
Well, but I think what you are saying essentially is there is still a lot of processes to work out in this. But let me ask Mr. Folorunsho. First of all, what's your take in all of these conversations that we're having, especially when it comes to this whole talk about the federal government borrowing from unclaimed dividends and dormant accounts? What's your initial take on it?
Well, thank you very much. You need to look at where is this coming from, what are the practices in other climes. If you go to the UK, this is a provision that is being used also in America. Now, the main thing is that these funds belongs to persons, individuals, and companies. Of course, why are they unclaimed? Either because the person died, or because is unaware, change of address, and a lot of other things can give rise to those funds being unclaimed and the bank account balances becoming dormant. Again, apart from those two items, if you go to other claims, people are entitled to pension funds and they don't get to claim them. People have life assurance policy and either endowment at their death. Maybe the family don't even have details. So these funds has to be put together and then, of course, managed. That is in other claims. So the provision of the Finance Act is only restricted to the unclaimed dividend and the dormant account. And of course, we know that government, in line with Section 306 of the Constitution, set up the crisis fund of 500 billion. And so this is just a subset of that to make fund available to the government. But of course, again, the most important thing is to be able to manage these funds on behalf of the beneficiaries. Government is a continuum.
Well, one would ask the question, first of all, if they are unclaimed dividends, dividends suggest that they are working, they've got it from certain companies, okay, that they invested in the company as shareholders and all of that, and so that is what that suggests.
Yes.
Is the federal government saying that the companies are unable or incapable of managing funds for the shareholders that gave them trust?
Now, if you look at the provision, it applies basically to public companies. For private companies, the funds can be held by the companies for 12 years. If they are not claimed, it goes back to the other shareholders. But for public companies, after 6 years, the provision says that this fund should be transferred to the unclaimed dividend fund. And then, of course, it also applies to dormant account. Now, if you look at the composition, the essence in other countries is to be able to manage this fund for the owners and to make them available as at when required.
Okay, but just a very quick one with Mr. Ofili. One of the questions that came to mind the other time when you said that you also foresee, in responding to Chamberlain's question earlier, you also foresee a situation where there will be a lot of litigation. Do you think that in executing this law, in crafting the law and in executing it, the crafters saw the possibility that that would happen? If the answer is yes, what is the plan to mitigate the risks and whatever it is, the issues that would arise as a result?
So what it is from our conversations now, you can see that there are certain gaps, right? Whilst the intention is laudable, like Mr. Fodmosha has said, this legislation or legislations like this, you find them in other climes, right, in other jurisdictions. And the difference here is that there are certain provisions, there are certain gaps that we catered for here, and it is from those gaps that I foresee areas of possible litigation, right? So for all intents and purposes, what it means to me is that the drafters of this particular provision perhaps did not consider every possible angle or consider every possible inclusion or factors that could have been included in this provision. I foresee. So for example, last year we had the Finance Act 2019. There were a number of provisions in there that were not clear. There were a lot of gaps. And what eventually happened is that the FIRS and other bodies issued guidelines, and the minister issued modification orders to clarify, issues that arose under the Finance Act 2019. I foresee that, something similar would be done for the Finance Act 2020, and not just for this provision, but for some other provisions that, the drafters did not foresee, or those provisions were not all encompassing. So going forward, I know that there will be discussions at different stakeholder fora rather, and people would come up with recommendations, right? And these recommendations would have to be considered by the drafters and by the relevant bodies for us to have some sort of modification of that directive, guideline, or regulations that would help us move forward with this. So, for example, we have mentioned here that there's no provision on what the rates would be for the yield, right? There are issues with respect to, when you said you've created a trust, right? And then you are borrowing from that trust. There are fine issues here that need to be addressed. But overall, the intention is laudable. I mean, we know that the government has borrowed a lot of money so far, and the government is actively looking for ways to raise more funds for capital projects and for other, things that they're looking to do, right? So this is one of the ways that they've come up with, but there's still issues to be fine-tuned here. That's what I'll say, and I know that there will be a lot of conversations around this, and we'll definitely hear from the drafters shortly.
Well, I wonder if people will not say the road to hell is paved with good intentions. But Mr. Ayiko, before you come in, let me ask Mr. Folorunsho. Part of the issues that have been raised here is that because when you reference what is the global practice, what happens in other parts of the world, so can a trustee borrow from a trust fund? Because government in this case is a trustee.
Well, we can't say government is the trustee. There is a governing council headed by to be headed by the Minister of Finance, and then of course another private person of irreproachable character. And we have a couple of, including the Shareholders Association, and of course a representative of the registrar, the DG of SEC, DG of NDIC, and so on. So whatever, presently government sells bonds, treasury bill, those are borrowings. So any fund that is left in the hand of government that is not strictly for government is purely borrowing. So what they're saying is that this fund is not just going to be held the way it is being held by a registrar. If you have unclaimed dividend and you make a claim to the registrar, they give you the money to you the way it is. But with this, you are going to have some yield, okay? And that is why it is said to be borrowing. Of course, it is borrowing by government because it is not government money, but it's being held on behalf of the owners. Why do we have the fund in the first place? Because the fund have not been claimed, because the money have been more or less abandoned. And what happens, what is the present practice? Who are the people benefiting from the fund as of today? Are they giving back to the owners in terms of unclaimed dividend? Are they giving any form of yield? Those are issues that also have to be addressed. Like the other speakers said, definitely there will be regulation that will guide, the operation. And that's why we have the Governing Council, who are supposed to make policies around the operation of the unclaimed dividend fund.
Okay. Basically, if you look at the major gap we are having, is because those who put this thing together jumped a particular step. And the critical step that should have been taken was to involve the key stakeholders in the discussions. For example, how can you be having a provision in the finance bill without inviting shareholders and shareholders association to listen to their own perspectives, without inviting the registrars, without inviting the listed companies, so that they will tell you the practicability of what you are proposing? Those people got to know about it, and that is why there has been agitation by the registrars, by the companies, by the shareholders to say, we were not consulted. You cannot invite SEC, invite stock exchange, and assume that they will speak for shareholders. They are not investors. So if they've done that, that would have solved a lot of all these issues would have been put on the table and they would have addressed them. And as I said earlier, as an institute, we support government borrowing from this, but it should be done in a clear way, as is being done currently. Government issues bonds and then compare these companies to invest in government securities. That is still borrowing, so that the terms are clear. Those companies will still have a track record of the instruments and whatever, and including the banks, and they can manage that process. And the major reason why the shareholders are worried is that what is the guarantee that we will get this money our members will get this money when they are through with the course. You know, the first bottleneck is that they are stuck in the course looking for probate. By the time they now get the probate, they now start another journey. And it's a new journey which is absolutely avoidable, because if you have requested the companies to invest in government securities, which is very liquid, they will sell it at any time point in time, and then they will pay those people. Now, the major challenge also in the act is that if you look at section 78D of that act, it provides that the DMO may establish an annual sinking fund. May. Look at it now. You are borrowing. Definitely you should be planning for repayment. That sinking fund should not be discretionary. It should be mandatory, so that when they come forward, they will be paid. The shareholders will not want a scenario whereby they become another pensioners that will be waiting. Government will acknowledge, yeah, we are owing you, but hold on, we are still looking. But if, for example, it is mandatory that you set up the sinking fund right from the outset, then everybody will have that mentality that the money will come, because it's trust issue. And that's why they agitated that. What is the guarantee that when this private fund is taken to government, that it will not become another bottleneck, that people will be queuing and unnecessary hassles? And that is why the government needs to rethink this. Let us address the real problem why these dividends are unclaimed. The real problem is that government should do something urgently in respect of our probate system. It's chaotic, it's exploitative, and it's very punitive. And when they address that, that problem will be solved. SEC has tried, CBN has also been working with the banks to ensure that the process is expedited, and we just need to put all hands on deck, sensitize the shareholders in such a way that they get their dividend as soon as possible. And also, as an institute, we have advised, let us proactively be thinking of how to manage future unclaimed dividends, because it is still loading. And what we need to do is that going forward, we should ask all existing shareholders, nominate a default beneficiary, so that if anything happens to the main owner, that is the shareholder, the dividend will be paid automatically to the default beneficiary's account. And we will not be forcing the beneficiaries down to go to the court to be looking for probate, because it is a difficult thing for them to access money to get 10% to pay on the property. For example, the person has a share, is not selling their share, these shares are not being sold, but government still requires that you pay 10% of the value of the shares that you are not even selling to government. You know the unclaimed dividend in the bank account has been liable to withholding tax. You will still pay 10% on the value of what you have in your bank account. So it's exploitative, and that's why we are saying we should look at it, and SEC should work in such a way that we streamline it, particularly future dividend, applications to be issued. We should have a default beneficiaries, and we should sensitize our stakeholders that whenever there is any issue, if, for example, you have an issue with your bank account, please get inform your registrar quickly so that they update it. And even when your bank account is working very fine, for the survival of your family, so that they will not be exposed to unnecessary risk, because a lot of people are suffering. The money is there, but they cannot access it. Let us nominate a default beneficiary. And for government, very simple. All this agitation we are talking about is absolutely unnecessary. If government now says companies manage your unclaimed dividend, banks manage your unclaimed dividend, however, 70% of the unclaimed dividend must be invested in government security. Government will have access to the funding they are looking for, and there won't be disruption of the system, because it's contractual. A shareholder will continue to go to the company, because the company has a contract with the shareholder, not with the government. So, and that is why eventually when there is litigation, these shareholders, they will join the companies, and it's absolutely a distraction. And that is one way. The other way is that, you know, because companies are now being compelled to remit this money to the government, very soon, various committees of the National Assembly, they will start calling on the public listed company to bring evidence that they have remitted the full amount. No company in this challenging environment has time for that kind of traveling to Abuja, making copious copies of documents in respect of the dividend you have declared, in respect of the dividend you are managing. It's not as if the shareholder asked for this dividend and they were not paid, but because there are bottlenecks. And that is why, for us as an institute, we believe that let us solve the problem. Let the federal government work with the various state governments, the attorney generals of the federation. Let them agree in such a way that the total amount that will be paid for processing probate or letters of arbitration should be a maximum of 5,000 naira. There is no reason why a person should be asked to pay 10% of the value of a house is not selling. If they are selling in future, then they will pay. But because they just need the grant, what they should pay is just 5%. For example, we have also recommended, if we are talking of property, the best each government can do is that in the state where we have land use charge, just insist that they must bring evidence of payment of the current land use charge or the areas of land use charge. Those are legitimate claims. But for you to be asking beneficiaries or dependents to be paying 10% of shares they are not selling, 10% of money that have been liable to tax, for example, if a worker earns money, all the salary is paid to the bank account after deducting tax, you are now asking that 10% should be paid from that same bank account that has been subject to the tax to the government again because the owner of the account is dead. It's a punishment and it's absolutely avoidable.
Mapa.
First, I'd like to find out, I mean, I don't think that Mr. Aiko has answered the question posed by Mr. Folorunsho on, who is currently benefiting from the regime, what currently is happening to the unclaimed dividends, because as you rightly pointed out, the money is there. And then two, are we aware of how much the government is really trying to make? What is the current, should I say, amount that we can possibly get from unclaimed dividends and dormant accounts? And what is the government proposing to shareholders who have unclaimed dividends? Do you think at the end of the day it will be worth their while? Let me pose this to Mr. Ayikov.
Very simple. Who is benefiting? The way it works currently is that when dividends are declared and they are unclaimed for a period of 15 months, SEC rule provides that 90% of the unclaimed amount should be returned to the company, and the company should put it in a dedicated unclaimed dividend bank account. That is where it will be. The registrar will be using the remaining 10% to service the shareholders that are available. And when that 10% is depleted, they ask the company to replenish. That is the arrangement. And CAMA provides, including the 2020 CAMA, provides that dividends that are unclaimed can be invested by the company outside the business for the safety of the fund. No company can invest unclaimed dividend in its own business. They have to invest it outside the business. And when we talk about who benefits, who lays the egg is the company. So this unclaimed dividend sits with the company. Whenever the shareholders are available, they will be claimed. And if there are interests or whatever on it, it is plowed back into the business in order to ensure that the company will be in a position to continue to be in operation and generate profit. So that is the arrangement as at now. It's the company that declares the dividend in the first instance. And whenever there are issues in terms of management, it's the company that is currently responsible. And what we are saying is this. We are not saying that we should do anything extraordinary other than for us to ensure the safety of the fund. And that is why as an institute we are saying that that fund must be invested in government securities. And it will be on clear terms. As at now, I don't see transparency in this whole arrangement. It is indirect borrowing, the rates are not known, of the yield, the terms of payment are not known. For example, if a shareholder after getting the probate now approaches DMO, within what timeline will DMO now pay the shareholder? That is not stated. So we just need to clarify this.
The second part of the question is that, because some dailies are reporting that the unclaimed dividends and dormant account funds is to the tune of 895 billion naira.
Yes.
So she's asking, what is the range that we're looking at here from your estimation?
No, basically the authorities are in a better position, and we have to rely on the report from SEC in respect of unclaimed dividend, a report from CBN in respect of dormant account. And so basically, what to me, the one that if we are to manage it based on our proposal is that a percentage of it, maybe 75%, 80% of it, the companies and the banks should be compelled to invest in government securities for safety. The reason why we have that provision in CAMA that talks about investing that unclaimed dividend in business outside the operations of the company is for the safety. We can make additional layer of safety by ensuring that it is in government security. We know one thing for a fact. Government has never defaulted on its borrowing. At least in the last 30 years that I've been working, I've never known of any instance whereby government borrows and they default. But we can talk of borrowings on clear terms because the terms are known. There will be sinking fund. This one, the terms are not known of the borrowing, and that is where the complexity is coming.
The question, I wanted to pose that. First, I want Mr. Folorunsho to respond to some of the things that you've heard Mr. Ayeku say, if you may. But then there is also the question of that transparency on the part of government. Do you think people will feel safe enough that their money will be with government as opposed to with corporate organizations? They find it difficult to collect the dividends from the private companies already. They find it difficult to get dividends of their benefactors who maybe passed on, or some of them that they have been trying and they are unable to, just as Mr. Ayeku also said. So what do you think can be done to ensure that those things are easier for people to access and not just another cumbersome process?
Okay, so if you look at the practice, he has alluded to there are no policies, we don't know what the rate is. The law has just been passed. I'm sure the Governing Council has not been appointed. The representative of shareholders is unknown yet, and which they will be bringing forward. So we cannot start condemning this provision yet, because it has not even been put to practice. But we can only look at what happens in other climes. And in some of those other climes, they even go to the extent of tracking those beneficiaries. They look at the fund and then look at the details of those funds and try to track it from the shareholders register. Because a lot of people are even unaware. That is why we have the unclaimed dividend fund. I mean, they are unaware they have this dividend. Some that are aware, there are bottlenecks, like he has said, for you to access those funds. So we believe that because a governing council will be put in place, they will also make policies that will make it easy for people to access the fund.
Part of the challenge that some lawyers have is that, look, the intention of government may even be defeated, because how will they borrow the money when some of these assets are subject of litigation within administration?
The funds are not subject to litigation. The funds are sitting somewhere, okay, in terms of dormant account balances, in terms of unclaimed dividend. The funds they are not subject to any litigation. And if there are no litigation presently against the company as to, we have, this fund belongs to us, shouldn't be any litigation when it comes to this fund now with the government. And there will be that certainty that at any point in time when this fund is desired, it will be made available. And like I said, for me, it is just like the first step, because there are several funds that you have securities with banks. The person dies, nobody gets to ask about the securities.
Yeah, but isn't it the procedure that, look, just as you highlighted, that, look, if they're deceased and then there's no default beneficiary, that hasn't been done yet, so cases are in court at the moment, so that has to be determined. Isn't that the process at the moment?
Exactly. And just to respond to what is said, which is a very valid point, and which is what is missing in this part. In other climes that he mentioned, the government, the fund, actually puts in place the tracking method.
Yes.
An effort to ensure that we look for this beneficiary. There is nothing like that about how to solve the problem. You see, as at now, it would have been better if, for example, there is a desperate effort to solve the problems of why are dividends unclaimed? What are we going to do? We cannot be putting that in the legislation. We cannot say it's only the money, the process, that is what the law. How we are going to solve the problem is for regulation. I don't think, because ordinarily, if the shareholders have seen this attempt to say, okay, we are going to address this problem in a different way. We are going to track the owners from the register. We are going to look for them so that they claim their monies, and also put in place some other measures. Shareholders, maybe their feelings would have been assuaged to say, okay, maybe they actually are thinking of how to solve the problem. And nobody is criticizing this law. No, I don't want anybody to have that impression. And that was why the Institute released the position paper on the 19th of November. We forwarded our position paper to the National Assembly. We forwarded our recommendation on how to solve unclaimed dividend to SEC. We are working with the government. We are saying that this effort is absolutely unnecessary. The clever way to do it without disrupting the system is to ensure that allow the banks, allow the companies to continue to manage this dividend, but compel them to invest this money in government security for safety.
All right, Mr. Folonshaw, your final thoughts, please.
Okay, thank you very much. See, the unclaimed dividend fund and the dormant account fund, for me, is a very good development. And like I said, it is more or less like a starting point for other funds that are, hanging out there that are not being claimed by the beneficiaries, or which the beneficiaries are not known. We have the life policy fund, we have security, we have bonds, several funds hanging out there that are not being claimed by the beneficiary because there's nobody that is tracking them. So this...
He's saying that challenge has not been addressed. What have they done about what you just said, because there's nobody tracking them?
So that is why a governing council, has been included in the act, so that they will sit down, They are going to be working with the Shareholders Association. 2 of their members will be part of the Governing Council, okay, who will set policies as to how this fund will be tracked and how this fund will be administered. The rate of interest that he's talking about, they will determine all of those, depending on what investment, what security these funds are put into.
All right, then, Mr. Albert Folorenshaw, Managing Consultant, Payable Professional Services, and then we'll also have Mr. Bode Ayeku, President, Institute of Chartered Secretaries and Administrators of Nigeria. Thank you for coming on as well.
Thank you.
And Mr. Chukwudi Ofili, Legal Practitioner, thank you for your time today as well.